right, it's ticked over to 11 o'clock, so I think we should go ahead and get started. We got a lot to cover today. So thank you for joining. Welcome to the Adult Use Cannabis Licensing in New York webinar presentation. Just to let you know, this recording will be posted later at thinkcanna.com. So if you really liked it and want to share it with somebody, please do so. Let's start by doing a brief rundown of the two companies involved today. So based in New York, Falcon Rappaport Berkman, PLLC, combines the deep knowledge and expertise of attorneys who proudly advise real estate professionals, closely held business owners, discerning families, and private equity firms. Canna Advisors serves as a trusted advisor to cannabis entrepreneurs who are starting or expanding a cannabis business. Their licensing experts have worked with clients to win licenses and start cannabis businesses in 31 states and internationally. So we're going to do these a little bit in reverse order. So to introduce Summer, she's seen as a powerhouse of project management. As a licensed attorney with a background in tax, business, and administrative law, Summer offers a unique perspective on the legal landscape of the cannabis industry, as well as a critical eye towards complex regulatory compliance. She also loves the outdoors and recently got her scuba certification in Nevada. I'll turn it over to you, Summer.
Thanks, Greg. That is true. And let's continue in reverse order here. So Greg Huffaker is the Director of Client Services here at Canna Advisors. He oversees the entire licensing application process, all of our business planning pursuits, the technical writing team, and overall project management. He's an expert in navigating the complex cannabis regulations and emerging state programs across the country. From his early industry work, maintaining a database of ever-changing cannabis laws, and his JD from Cardozo School of Law, and being a Colorado licensed attorney, Greg brings a deep knowledge of legislation that impacts our clients at every phase of business. Next up, continuing backwards here, from Falcon Rappaport Berkman, we have Moish Peltz. Moish chairs FRB's Intellectual Property Practice Group and focuses his practice on intellectual property and business law, and helps communities grow their businesses and brands. Moish also supports FRB's commercial litigation and emerging technology practice groups with a focus on cryptocurrency, which I find really interesting. Moish is always doing webinars on cryptocurrency as well, so feel free to catch one of those. Next up, we have Matthew Rappaport. Matthew chairs FRB's taxation and private client groups. He concentrates his practice in taxation as it relates to real estate, closely held businesses, private equity funds, and trusts and estates. He advises clients regarding tax planning, structuring, and compliance for commercial real estate projects, all stages of the business life cycle, generational wealth transfer, and executive compensation. And then lastly, from Falcon Rappaport Berkman, today, actually, we have Ariel Holzer subbing in for Ken, who couldn't be here today. Our thoughts are with him. And thanks so much, Ariel, for joining. Ariel directs the real estate department at FRB. Ariel's practice encompasses all areas of real estate practice, including commercial transactions and development, real estate litigation, zoning and land use, and real estate related administrative law. So very excited to hear his take on New York real estate today. All right, here's our legal disclaimer for all our the lawyers on the webinar today. Just giving everyone a second to read that.
And non-lawyers, if you're here, you should listen. You should read this. Yeah.
Oh yeah, sorry. The disclaimer is for lawyers. Everyone should read it. All righty. Okay, and with that, let's get into the meat of it here. Start off with an overview. If you were at our last Canna Advisors webinar on New York, you got a really broad overview of the statute itself, especially with a focus on licensing. If you missed that, it's on our website, thinkcanna.com. You can catch that recording as well. So let's just quickly set the stage here. This is a continuation of that webinar. We're going to dig deeper here today. So you guys probably all know New York passed legislation in March of 2021. Decriminalization went into effect on April 1st. Retail sales and business licensing are going to come later on down the road. And then we're still waiting for those regulations, as we know. And also still waiting on the members of that commission to be appointed who are going to be the ones that make those regulations actually. So, from our perspective here at Canna Advisors, having worked in many different states across the country, over 30 states across the country, we have a really broad perspective there. So let me turn it over to Greg to just talk about what we've learned from other states. Greg.
Thanks, Summer. So, the first thing to note is when we see statutes legalizing cannabis, whether medical or adult use, they contain different level of detail. And New York's is extremely light on the details of the program, which means that a lot of it is left up to regulation. This isn't unique, but it is fairly rare. So that means that the area we're in now of the creation of regulations is when many of the program details are getting worked out. And what we know from other states is that this phase is a time in which they're gathering information from a lot of places. One is the existing medical operators in New York who are going to have their opinions about how they'd like adult use to be run. Another, of course, is the current regulators administering that medical program in New York. They're not just going to look to those regulators, though. There's two other categories. One is other regulators within the New York State system and local system as well, of course. And finally, we know that there's a lot of interstate interest in regulatory matters, so that the regulators in New York will be also talking to regulators from other states. Indeed, there's even organizations for cannabis regulators to join together and share ideas. And also, we have seen in a lot of states, and certainly hope it happens in New York, to ask for a lot of constituent input. People who are attending today and want to give their input to get into the adult use program to be able to do so. So we're in this timeline area right now where they're working on those regulations. Looking to other states, we see several things can happen. That we're looking for two distinct sets of regulations ultimately. The details of how the actual program will function and the details of the application period in order to get to that. Some states will put out the regulations for just one or the other, or sometimes they'll do both. So in Illinois, they just pretty much put out the regulations for application and left all the details for your application to just whatever was in the statute. If that's the case in New York, that would be pretty difficult because there's so few of those details. Some other states have flipped it in the other way, and some states just put it all out at once. Some states like New Mexico are working on it right now and sending out a lot of proposed rules in little chunks so that you can get a lot of that public input, notice, and comment. Others prefer to wait and have one big unload. So we're just gonna have to wait and see as we're in this middle period, and they're contacting these people and working on these things to see what details we get. Okay, Summer, why don't you tell us more about the business structure and what details we do know from there?
Sure thing. Yeah, as Greg said, the statute that we're working with here, the Marijuana Regulation and Taxation Act, MRTA, is pretty limited, but we do know that licenses will be awarded for cultivators, processors, co-ops, distributors, retailers, on-site consumption, deliveries, nurseries, and micro businesses. So quite a slate of licenses there, along with some extra special permits that they're giving out as well that, a few of those are really interesting too. You can learn more about that on our past webinar. But another thing to definitely keep in mind here is that New York is not allowing vertical integration. So that means owning all of the license types, or at least, you wouldn't be able to own a retailer, a processor, and a cultivation all in once, right? So having all three of the main license types there. The goal here seems to be to follow the tiered structure seen in New York's alcohol market. And so that's just making sure that it's separating manufacturing from wholesaling from retailing. However, it does allow for some multiple license holding. So if you're a cultivator, once you get your cultivator license, it seems like there will be an application process for you to obtain a processing license there. As well, one more exception to that no vertical integration is that micro businesses will be able to vertically integrate. However, we're not sure yet what restrictions they might put on micro businesses. So, how much they might limit the size of those micro businesses that can be vertical. Okay, so that just gives us a little, rundown of the business structure that we're talking about here in New York. And now let me turn it over to Moish to give us a rundown on the tax issues that we can expect to see.
I will let Matt handle the tax issues.
Oh, sorry, Matt.
I was fearing that Moish was going to steal my thunder, but nevertheless, okay. So I will sort of run down here. I think it's constructive to run down how it works on the federal level and also how it works on the state level, both of which are going to diverge pretty far from each other. To begin, as far as the federal level, everybody involved in the cannabis business in the United States understands the general function of Section 280 Cap E of the Internal Revenue Code, which broadly provides that if you have a business trafficking in federally controlled substances, including anything on Schedule 1 or Schedule 2, you are disallowed from all of the deductions that would be normally allowed to a business under sections 162 through 170 of the Internal Revenue Code. What does that mean in plain English? What it means is you basically can't deduct any of your expenses. Not only does it mean you can't deduct your traditional expenses, such as, what you pay your labor or paying your rent or your utilities or anything else along those lines. It also disallows depreciation and amortization deductions, things that you don't pay, but things that you instead incur. That is pretty harsh. The one thing that the IRS has interpreted that it does allow you to deduct is the cost of goods sold. So you get a cost of goods sold deduction, sort of related to the cost of your inventory, but you don't get deductions for any of the other stuff that would traditionally show up on the tax filings of just a regular business that doesn't involve trafficking a Schedule 1 controlled substance. So as you can imagine, with legalization picking up for both medical use and recreational use across the United States, there have been a series of cases that have actually wound their way through the courts, and recent decisions have come out in exactly interpreting what you can and cannot do, mostly what you cannot do, in order to try to structure around 280 Cap E, right? I'll go over a couple of these decisions just to give you a sense of what has already been attempted. And if you're thinking to yourself, wow, it's a super harsh statute that's in the Internal Revenue Code, what can I do in order to plan around it? Here's some examples of stuff that you can't do. The Alternative Healthcare Advocates case, that was in 2018. The court ruled in that case that using a management services organization doesn't work. So that's a model that's pretty common in private equity, right? Private equity, what you'll have is, especially in the event that private equity is trying to own a business that requires licensed ownership, like a medical office or an architecture firm or something else along those lines. It's very common to say, this is what we're going to do. We're going to carve out all of the non-licensed work, meaning all the back office. We're going to put that in another entity over here. We're going to have a management services contract where we take all that back office and all that management and all of the administrative function, and we'll have a contract with the licensed entity saying, listen, you give out, medical services or architectural services, but you're paying us for all of the non-professional services that need to be done as ancillary support for the licensed services. And what that allows private equity to do is own the management services organization, kind of suck out a lot of the profit from the licensed entity, maybe even all of it, and extract that profit for the private equity firm's benefit. So American Healthcare Advocates basically turned around and said, hey, that seems pretty nifty. Why don't we try it in the cannabis business? And the court struck that down and said, no. The businesses are too interrelated. You cannot have a management services organization to kind of like suck out the profit or otherwise redirect the amounts that would be taxable to the cannabis business and bring it to a management services organization. They said, no, you can't do that. So that you can't do. San Jose Wellness, what was San Jose Wellness about? That was this year, by the way, that was 2021. It's a relatively recent decision. San Jose Wellness was a case in which there was cannabis that was being retailed out as part of that business, but they said, listen, we have other products here that are not cannabis related. We have t-shirts and we have we have different paraphernalia that's like may or may not be related to cannabis, but we've got it under this roof. And what we feel is we should be able to carve out those incidental items as a separate trade or business. And that trade or business will not be subject to 280 Cap E. And the court said no. They said, if you have stuff that is merely incidental to the cannabis business, we're lumping it in. 280 Cap E applies to the entirety of the entity and all of your receipts. And, too bad, so sad. What did pass muster, however, is actually under an older case, which is the Californians Helping case, which is in 2007. In 2007, the court evaluated that case and evaluated that business and said, hey, you actually do in this case have a separate trade or business that can stand on its own. you have a cannabis related business that was medical. It's not recreational. Recreational was not illegal at the time. So you have a medical business, and you have this business that's really like support groups for people that are suffering from all these different medical problems that cannabis helped them alleviate. And what the court took a look at it and said, the caregiving part of this business is, it stands on its own. It's got enough to turn a profit on its own. It's got enough to, if you carved out the cannabis entirely, you'd still have a legit trader business standing on its own. And in that case, even though they were both under the same entity, they allowed the business to carve out the cannabis and the non-cannabis, and then did not apply 280 Cap B to the non-cannabis part of the business. So what's the distinction there, right? For those of you who are in this realm where you might be operating a cannabis business, but also you might have bolted on, or you might have closely related to it another business. What is the threshold that you'd have to reach in order to make sure that the other business could be carved out and 280 Cap B might not apply? Really what you have to do is you have to make every effort possible to show that if you have another business involved in this, that business could stand by itself as a profitable enterprise. And to set yourself up for that, what I would suggest that you do is have as much indicia of separate businesses as you possibly can. There are many, many lengths you could go, and you can mix and match what measures you take, but all these measures will help. Let me give you some examples. If you conducted the two businesses out of separate entities, that really starts to cascade into all the different other things that you want to do. That'll include separate books and records. That'll include separate employees. If you can't separate the employees, try your best to have an employee leasing arrangement at arm's length. If you have separate equipment and you're not sharing equipment, that's good. If you have, for instance, if you were to have one building with separate entrances and each of those entrances labeled with the different entity names, that's good. Each of these different things is going to show that you have separated these things out into two different businesses, so that even if you have a procedure that's required by state or local law that says you have to take certain measures in order to restrict entry or otherwise screen the entrance of a cannabis related business, but not of the other business, you may legit have two different entrances and tell people on the way into either business, hey, look, you know, if you'd like the cannabis related products, you got to go in that way. If you'd like the non-cannabis related products, you got to go in the other door. That's actually going to help you in my estimation, right? Subject to the disclaimer we had at the beginning of the program. The way that I feel is I think that's going to help you quite a bit when it comes to a 280 Cap B audit, because you'll be able to take all those non-cannabis items and deduct all your regular expenses for that. You know where that's going to help the most? Probably not only is it going to help the most on the employee side, because employee costs are quite big, labor costs are big, rent is also a big cost. And you'll be able to allocate rent to the non-cannabis business and be able to deduct it, which will be a pretty nice thing. So those are some tips in terms of, okay, if we've got some incidental non-cannabis businesses, can we separate those out and make sure that we don't get the punitive treatment in our non-cannabis business? Those are some things that you can do. But right? What if you're running purely a cannabis related business? If you're vertically integrated, what it may allow you to do, it's a little bit tough when you go on down the chain, but in terms of a cost of goods sold deduction, if you own both the distributor and the retailer, right? Or if you own the grower, the distributor, and the retailer, right? And Summer was just talking about the idea that there's restrictions on vertical integration, especially with the MRTA. That's more what Moish is going to go over. But if you happen to be vertically integrated, even in a different state, right, then there's ways you might be able to tinker with costs of goods sold between your related businesses in order to try your best to eke out a deduction and not show a profit maybe at the retailer level. Here's what you're going to need to do if you want to take that route. If you're going to do that, if you haven't done this already, what you would want to do is you want to have what's known as an internal transfer pricing study. Because what the government is wary of, and this goes across even businesses that are not regulated businesses with controlled substances, they want to make sure if you're interacting between two separate businesses owned by largely the same people, are you charging fair prices between the two businesses? And the way you can show that, and the evidence you can use to support that, is an internal transfer pricing study, which is typically done by a valuation firm. And what you do is you bring them in and they say, hey, if you've got a distributor that's charging your retailer for the inventory it's buying from you, then this is a fair price that ought to be charged. And how do you determine that? And there's an independent firm with metrics for that. Can you try and justify it with your own numbers? Sure. But in tax audit land, those are self-serving numbers. So it's a lot better to get an independent person to commission a report. So if you're vertically integrated and you want to try and use the cost of goods sold deduction at the retailer level, you should have an internal transfer pricing study in order to support that. I'm going to leave off with one more thing on federal before I move to state, and I will evaluate some of the questions that come in here for a second. But I want to talk about one of the things that we've been kicking around in the office that has not yet taken. It's a complicated idea, but I'm just going to say one sentence on it. And if you'd like to know more, you can always contact us separately. But we have kicked around the idea of whether or not you could use the tax-free vehicle known as private placement life insurance in order to try and get around 280 Cap B with even a purely cannabis-related business. In a nutshell, what that would entail is you would have recapitalization of your cannabis business into 1% voting equity and 99% non-voting equity. That non-voting equity would be owned or wrapped inside of the cash value of a life insurance policy. It's a little bit of a crazy concept, but under American tax law, the cash value of a life insurance policy is not taxed on its income until the income is removed from the policy. It's nifty, it's complicated, we haven't implemented it yet, but for especially larger operations, it might be worth the costs of implementation. But this segues nicely into some of the questions that have come in, which is, Kenneth asks, is Congress likely to change tax deductibility? Here's the thing about that, right? The way the tax code reads is it says, if you're on Schedule 1 or Schedule 2, all these prohibitions apply. So Congress actually doesn't even need to change the tax law. It's just that the DEA needs to take marijuana off Schedule 1 and move it to something other than Schedule 2. If it does that, then all of a sudden the tax law doesn't apply anymore. Then you turn around and say, oh, all these things that punish me for running this business, they don't apply because marijuana is not on Schedule 1. That is actually, to my knowledge, I'm not a DEA guy, I'm a tax guy, but to my knowledge, that's an administrative decision. That's not a that's not a statutory decision, right? And Kenneth says, the rescheduling of cannabis and psilocybin is a great idea. Listen, we don't have to get into politics, but I agree with you on a policy level completely. Okay, so that's good. And then let me check the Q&A here. Okay, so
hey,
Ari,
Matt,
hi Ari. Ari asks,
Matt, I'm sorry to interrupt. Why don't we
yes,
save the questions from the end? This is all super interesting.
Okay,
But Moish, do you want to
we'll
cover
save 'em.
intellectual property now?
Yeah, sure. Well, thank
Thanks,
you, Matt Summer, Canna Advisors,
No
for
worries.
having us. Yeah, so in terms of the intellectual property, there's a number of issues here also that I think kind of stream downwards from that Schedule 1 decision, right? Because in terms of intellectual property, there's a number of different things that I think every business should be thinking about. I mean, primarily in my mind, I do a lot of trademark work, would be building a strong, prominent, distinguishable brand for the business, right? The problem with that is if you go to get a federal trademark registration for something that is illegal under federal law, such as selling a Schedule 1 substance, you're not going to be able to do that. The Trademark Office currently, this is a federal issue, right? It's going to say, no, the goods that you're selling are federally legal, even legal at the state level, so you're not going to qualify for federal trademark protection. Now, there's ways you can get around that and still get some type of federal trademark, which is what I would recommend that you think about doing if there's some other legal activity that you're doing at the federal level, such as you're selling, merchandise, you're selling, some, ancillary products like pipes or things like that, which are legal to be sold federally. You can get a federal trademark registration for that good or service that you're offering. But it's not really going to help you for the core of what you're doing, which is, cannabis sales or cannabis growing or something like that, which is ultimately what you want to protect and what you want to protect on a national level. Because I think the idea is, well, if you grow a brand in New York and 5 or 10 years down the road, you're able to expand on a regional or national level. You don't want to get across the state border and find that you're unable to do that because someone else is using a similar name, outside of New York State. So that's the goal there, I think, with federal registration, is to try, to the extent you have a goal or a long-term goal of having a presence beyond the state and you're thinking long-term, you may want to consider federal trademark protections for certain things that you're doing, that you're able to get that. And I can dive a little deeper onto, why the Trademark Office is acting that way and how they're making those decisions. Might be a little bit too in the weeds there. On the other hand, there are below the federal level, there's state and common law protections. Most businesses, probably most businesses outside the cannabis industry, are just relying on common law protections, right? They're just using a name, they're not really thinking about trademark protection, and they're just, but use in commerce, right, is going to get you trademark rights. But it may be very difficult to go into a course to enforce those, to cause someone else to shut them down, or even to protect your ability to continue using your name if someone tries to do that to you. So that's one of the benefits, I think, of trademark protection. It's not necessarily offensive. You're not thinking, hey, I'm going to be a jerk and go force someone else to stop using a name that may or may not be similar to mine. It's, I want to secure my name and be able to use my name and not have an issue down the road if something else comes up. It's like insurance, right? So I would really recommend that people at the very least in New York State think about a state trademark, which is going to, it's only available for use in commerce. So you have to actually be using the trademark, right? Not before you use it, which at the federal level you can do one before you actually start selling. At the state level, you can do it once you're already selling, and that's going to protect you within the New York State. So, it might be a combination there, right? Where you try and get federal protection for trademarks for certain types of goods or services. You get state protections for ones which might be more core to the cannabis business. And then there's other things you can do. You can get copyright protection, which would protect, that's the federal level, would protect your logo design configuration, right? The artistic expression of that design. And you can also do licensing scheme, right? So if there's, if you're a company that's operating in multiple states, you can, license someone else the right to use your name. And that way you can gain presence in another state, right? By doing that, perhaps. So I know larger companies are looking at that, and they're branded at, as that larger company name, and they have trademark registrations for that, that multi-state name is going to be protected on a federal level, and then perhaps there's state level protections for different things. Just real quick, something to think about is patent protection and planned patents. There's definitely going to be opportunity there for people that are innovating, and perhaps also in the manufacturing process, if there's things you're doing that would qualify. And then lastly is just the idea of enforcement and litigation, both on the offensive and on the defensive end, right? So I'll start with just protecting yourself, right? When you're thinking of a name, what a lot of cannabis brands have been doing is thinking of some really popular, consumer product like Skittles, and saying, well, if I do I just put a D in there and change it to Skittles, then maybe it's okay. And this big consumer packaged good company isn't going to come after me. So far, that does not seem to be the case. It seems like the really big brands that have non-cannabis consumer packaged good companies are being super hyper attentive and hyper aggressive at enforcing their brands outside from outside the cannabis industry into brands that are starting up trying to use some derivative of that. So I've gotten inquiries already of, hey, is it okay to use this? It's a really obvious derivative of some famous national brand. I would say don't do that. Think of something original, both from a liability perspective and also just from a just good business sense. You're going to want something that's creative, and you're going to have the ability to protect, and that's going to set you on for hopefully a path for growth and be able to distinguish your brand in the marketplace. And then separately would just be doing all these things the right way. If you see someone else that really is stepping on your turf, thinking proactively about what sorts of things you can do to establish yourself in the markets, that if you do need to turn to IP protections from on an offensive perspective, that you have the ability to protect yourself and preserve your ability to continue building, growing, using your brand. So that's the IP chunk.
Awesome, thanks. Yeah, so to quickly cover competition, you heard me say before that there's not a lot of details in the statute. Sometimes that's good. The absence of details can be helpful. So competition-wise, it's looking like we're going to be fairly balanced. The rumor is that the state's going to be targeting one dispensary per 20,000 people in population, which should end up being between 900 and 1,000 dispensaries. It's unlikely those will all come out at once. There will probably be rounds of licensing as they look at how it's going. Because there's no ban on setting a cap like Oklahoma, we're not going to see totally open licensing, nor is there a really stringent cap as we saw in places like Florida, in which there's only a few people who can get in and then very little competition. Okay, so there's plenty of stuff you can be doing now. The first area to cover is the financial plan and funding. The first thing you want to do is figure out how much it's going to cost, right? be working with a lot of spreadsheets, getting those details down, and trying to get as many figurative numbers, locked in with quotes, and, get as many concrete things as you can. When you're doing that, you want to be planning, of course, contingencies like you would in any business. Once you've gotten all your contingencies down and as many assumptions and confirmations you can get, you want to be revisiting that minimum cash position. Because there's a lot of unexpected hiccups that can happen in a cannabis business, particularly starting up, we find that having a good buffer after you've planned for every other buffer is a really wise decision. For example, in Illinois, for certain license types, you would have acquired your property in mid to late 2019. Those licenses still haven't been awarded. So if you're leasing, you've been paying that lease this entire time. And you don't want to get into a situation where you're in a cash crunch and subject to predatory practices, which I'll cover in a second. The next thing, after you figure out how much it's going to cost, is who's going to pay for it. If it's not just you, then you got to be figuring out outside investors. There's always a balance between, do you want a lot of people and no one has any particular power, or do you want just a couple and less to coordinate but more single power? Everybody's answer is different. I have an idea of your perfect idea with a range, because rarely does investing work out perfectly how you want. As you're working through that funding plan, know that you likely will be able to get a bank account, a checking account, from probably a credit union. It is extremely unlikely to impossible that you will get a bank loan from a normal bank. And it is extremely unlikely that your big bank you're used to working with will give you a cannabis checking account. There are private banks, meaning that they don't have federal master accounts, who may give you a loan, but they're going to want that loan secured, probably with assets outside of the business itself. A great place to start with your pitch is with friends and family. If they have the money and you're happy to work with them as your investors, all the better. If not, you got to practice, and it helps spread the word. It's really important to network in this industry, and a great way to find funding. So go to conferences, shake all the hands you can, come in with your pitch deck ready for anybody who's interested, and your presentation if they want to hear it. And be aware that there is a lot of VC predatory practices in cannabis. There's certainly some good practices too, but read those type of agreements closely and be aware that you could be giving up a large chunk of your company and or have a really usurious interest rate. Summer, you want to tell us about assembling the team?
Certainly. Yeah, I think this is a great one for right now, because you really don't need the regulations to assemble your team. It's very unlikely that they're going to ask for too many surprise things when it comes to your team. The things that we see in applications across the country is they're going to look for cannabis expertise, right? They're going to want someone who has experience in a cannabis industry in New York or outside of New York. Obviously pretty limited within New York, right? With just the medical program going there. So you may extend your search outside of New York, and that's all right. Business experts, definitely people you want on your team right now, especially if you're looking for investors, you're going to need these people for that process. So having lawyer, accountant, a CEO type person who's going to be able to handle the business administration, business leadership kind of functions there. And making sure those are people you can really count on, and if you're going to investors, your investors are going to know it's not just you, this one supposedly superhuman trying to run the ship here, because there's just too much for one person to do. They're going to want to know that you have a group behind you, a strong team. It just makes it seem real, right? A real project that you can depend on. Also, you're going to want community connections. So if you're not from the local city, finding connections from people who are. If you are from that local area, even better, just making sure to, reintroduce yourself, shake hands, talk to your local connections and network that you have there. And like Greg said, get the word out about what you're trying to do. Practice your pitch and that sort of things on those folks, but start bringing them into the fold, putting your dream team together. That's something you can definitely be doing now. As far as finding those people, there's 3 big ways that I would recommend doing that. First is through grassroots, right? That's your friends and family, your own network, reaching out just to see who you might know that might fill some of those positions that you need, and who those people might know, so on and so forth. If that doesn't work out for you, which, totally normal, you can look to online platforms, of course, Indeed, Monster, LinkedIn, things like that for job postings. We've heard people that are exceptionally successful finding lots of qualified candidates on Indeed, though it does take a lot of legwork to sift through those resumes and do the interview process and all that yourself. So if that's not for you, you can always turn to an executive search firm. They'll help you find extremely qualified placements in the cannabis industry, and you can also find them outside the cannabis industry as well. So those are the big 3 ways to recruit. So, keep in mind, people are finite, right? The best people are going quick. They're already joining teams now. And so you want to start looking for them now, whether whether you're going to start paying those people or maybe introducing them to the team for an equity percentage, that's up to you and something to think about with your team as well. So like I said, people are finite. Another thing that's finite is real estate. So let's move into that and talk about real estate. I know that's what everyone's dying to hear about here in the New York market.
Sure. It's a pleasure to be here today. Just a few things to get started on. As most of you are aware, the MRTA, Marijuana Regulation Taxation Act, included an option for the dispensaries and on-site consumption licenses for a local opt-in, opt-out, meaning that localities can opt out of allowing dispensaries or on-site consumption. They have a deadline for the initial opt-out of December 31st, 2021, so the end of the year. The opt-out, if a place does opt out, that doesn't necessarily mean it's the end of the story. The locality can repeal the opt-out and decide to opt in at any time, which could become a factor later. As I don't know how much we want to go into in depth, but as it's been remarked that I'd say most of the towns and municipalities on Long Island right now have expressed their interest in opting out. For a brief list, Rockville Center, Freeport, Atlantic Beach, Island Park say they intend to opt out. Garden City says they intend to opt out. Town of Hempstead have voted to opt out. Riverhead expects to opt out, as does Oyster Bay, Huntington, Lindenhurst, West Hampton Dunes, Babylon, East Rockaway, Lynbrook, Williston Park. The few exceptions here, Shinnecock Indian Nation, Southampton expresses that they plan on opting in and they'd like to get started before the end of the year, which based on what we've been told will not happen. But Southampton says that they plan on opting in and are focusing more on regulating. Sag Harbor, the mayor is considering opting in. Quogue and Southampton haven't decided yet. East Hampton, the supervisor supports allowing it, but they don't expect to have a board meeting on it until the summer. East Hampton Village, they plan to opt out. Westchester is an area where apparently it seems like most of the places there will, at this point, at least have not expressed an interest in opting out, will opt in. But again, there will be regulation. Town of Islip, Smithtown, Southold, they've all said that they need more information, and Northampton is opting out. So that's just a brief list of localities. New York City, of course, the big one, is expected to opt in, but with regulations. And just to get into that briefly, so once a locality opts in, the local governments are prohibited from preempting the state law or introducing. Basically, this is designed. They can't introduce their own secondary local licensing provisions to go along with MRTA. It's you opt in and that's it. But and here's the but: all building, fire, health, and safety regulations apply. Local law applies, as does reasonable zoning regulations. And that brings the question on zoning. Most places haven't really considered zoning yet, since it's a new area. Just in terms of New York City, when medical marijuana was permitted in New York City, they did not create a new use group. I should backtrack. In New York City and in other localities, different functions and different functions and different uses are split up into use groups where they're classified, and based on the zoning, the zoning of the area will determine whether that use group is permitted in that specific location. When medical marijuana was permitted, they did not create a new use group, and most of the certificate occupancies in the city for medical marijuana use are either currently classified as medical offices or as use group 6 retail, regular retail use. We don't know whether that will change now that MRTA is obviously a much broader law and much broader rule than the medical marijuana provisions. So that may introduce new changes, and there may be new zoning guidance to go along with that. Obviously, if you're classifying under medical offices or use group 6, there's a relatively large range of locations where it can be located within the city. Use group 6 is your classic retail location. Medical offices are obviously located anywhere retail is located. Also would be located in larger scale residential areas, which most likely is not going to happen for MRTA, but remains to be seen. And again, going along with the opt-in, even once a place opts in, you're not necessarily done. Once you found a location that opts in and you find zoning that works for you, you're not necessarily done. Once you apply for the license, the local municipality, or in the case of New York City, the community board, is going to be sent notice and will have an opportunity to give their opinion on your license. And the Cannabis Control Board, first of all, the Office of Cannabis Management, when they present your license, must include this opinion with the application. And the Cannabis Control Board, once they reach their determination, has to include in the determination how they factored in the local opinion to their determination. So your representation from a local community board, local municipality is extremely important. It's not something that you can forget about once you've the local connection, I should say, is extremely important. It's not something that you can forget about once you find your legal use, your legal zoning, and the opt-in, and just say it's a state license, I'm going to the state. You should be very in touch with the local stakeholders. Just for some, and just for some color in terms of provisions, and I think we'll touch more on this maybe in a different slide, but there is, if people are familiar with the alcohol rules in New York City, there is a similar provision in terms of location. There's a similar, what we call here in New York City, we call it 200-foot rule. They have, which is that you cannot locate a store selling alcohol within 200 feet of a school or a house of worship. So they've done the same thing with dispensaries and on-site consumption locations, but in this case, it cannot be located within 500 feet of a school or 200 feet of a house of worship. They also have very stringent advertising laws. And the advertising cannot be located within 500 feet of a school, house of worship, daycare, playground, park, library, or it cannot be on or within public transportation vehicles or stations. So that's in terms of advertising that piece. I think there's
Thanks, Ariel. Yeah. Thanks. I think we're getting close on time. That's all super interesting, but let's I think a good segue to pass it over to Greg on how to approach local governments. So, once you're into those towns, how to talk to them. Go ahead, Greg.
Thanks, Summer. And I'm sure there's going to be at least one watch on the replay, because I'm definitely going to go back and listen to those comments, Ariel. Thank you so much for all that. Really interesting to hear all those towns. So yeah, when you are approaching that local government, the first thing to keep in mind is be professional. Particularly we're thinking about upstate New York, you're going to be meeting with some folks who probably have a preconceived notion of what a cannabis business owner is going to look like. So basically don't come in tie-dye, right? Dress well, make a great impression, become that trusted resource for them. There's a lot of stuff to mention when you get the opportunity to anybody in local government. I'm just going to run through a few of them quickly. If you're really interested in this, I've given a whole hour-long webinar about approaching local government through NCIA. So job creation. Cannabis businesses, A, employ a lot of people, but B, there's a lot of ancillary employment coming. They're setting up a new business, so they need all the typical contractors you would. It has increased security and safety. Despite all the press around robberies of cannabis businesses, they are rare and they are safe. And you find in municipalities that have legalized, detectives often view cannabis business as some of their best partners because they have security guards and because they have cameras, excellent cameras that are recording all the time. It's important always to point out tax revenue, not just from the cannabis tax, but property taxes, payroll taxes, sales taxes, lots of good stuff. Cannabis businesses really care about being good members of the community. And another thing to point out there to local regulators is how much they donate to local nonprofits and other charities, and that you can be asking questions of where you think your dollars could be best spent in that municipality were they to allow it. If there's a food bank that could really use help, that kind of thing, you want to be there to help them, right? It's important to also point out to a local regulator that cannabis is going to be sold in their community, whether they have a moratorium or not. The question is whether it's going to be drug dealers doing tax-free sales and not checking IDs, or you legalizing and having regulated, safe, tested marijuana that's only sold to people whose IDs have been checked. Finally, tourism is a really important thing, again, particularly in upstate New York. And this isn't just the traditional, someone is going somewhere in order to consume adult use cannabis. We saw what happened with people planning a ski trip once Colorado legalized, is that you might be looking at Utah or Colorado. You may choose Colorado not to go consume cannabis, but to go skiing, and knowing that cannabis is an offered amenity in that jurisdiction. Now let's quickly touch on border town considerations. Though it is illegal to cross state lines with cannabis, statistics clearly show that it happens. Trinidad, Colorado is a great example of this, where it's a very small town with over a dozen dispensaries that do a lot of business. As New Mexico gets their program set up, we're probably going to see a large drop in that in the long term as less people start traveling to those businesses, and some are going to be in trouble. That said, there are some border towns that continue to see a lot of cross-border traffic. For example, in Portland, Oregon, there's a large amount of Washington IDs being checked there. Why? Because taxes are higher in Washington than Oregon and supply is lower. So that means much higher prices. People are willing to travel. The other reason can be that dispensaries are very sticky, in that the first dispensary someone goes to and builds trust with, they tend to keep going to, even when cheaper and closer options pop up. There are ways to unstick, but that's fighting from behind. Okay. Ariel, I would love to hear more about your thoughts on some of these considerations we've discussed before.
Sure. So, yes, there are a couple of issues that prospective tenants and landlords should keep in mind here. And obviously, these are, and everything that we've said so far, we're in the very, very beginning of this, and there are bound to be more regulations as we go on and updates, and people should keep that in mind. But in terms of things to look out for now that are in the current rules, the licenses, once you have a license for a dispensary on-site consumption, those are non-transferable. And non-transferable here is extremely strict. This means if you have a shop and the store next door, closes and you're doing very well and you want to expand, you're not going to be able to expand your space before you alter your license for the OCM. You have to go back to the Office of Cannabis Management and get that in the license that you can have additional space. Additionally, if you're located in a building, in terms of location and things that you should be looking out for, the location for a dispensary or on-site consumption location must have an entrance that is on a public street, on street level and in a public street, and on a public street. It also cannot have entrances to any other part of the building that's not licensed. And this can become sticky for things like, obviously, if you have a second store that's selling non-cannabis items, they can't be connected. It could also become a little bit tricky when you're talking about fire exits that in many cases enter into a common area before the egress from the building. So those are things to look out for that may be a sticking point in licenses with a tenant, and also for a landlord to pay attention to. Another point that tenant, and this is also for the landlord, is that the applicant has to, before he files for the license, has to demonstrate his control of the premises either through ownership or a lease or another document which would give him control of the premises. The term the term must be longer than the term he's seeking for the license. Again, this is something that can be tricky, especially when you're starting on you're asking for a license, because you're basically going to have your location in hand before you're filing for the license, and that could mean a lot of expenses until you finally get licensed and are able to open. And then something for landlords to look out for is to be extremely careful of vetting, because if a license is revoked, the OCM has within its power that they do not have to, that they would not grant a license to the same location, even a new dispensary or something in the same location for a 5-year period. So if you make the mistake and enter into an agreement with the wrong person and they get their license revoked, your ability to market the location to someone else is going to be extremely infringed. And finally, another note for the landlord is check carefully with your mortgagee and your lender, because many lenders currently, because of the tricky position we're in with the federal law, will have prohibitions against this sort of use for the premises. You may need to seek a refinance with a less traditional lender. So it's something to keep an eye on before you enter into this.
Absolutely. Thanks a lot, Ariel.
Thank you.
All right, and with that, I think it looks like we have just a little under 10 minutes for questions. So I know you all have sent a lot over. We'll try to get to as many of those as possible, and we'll send answers to the rest afterwards. So first off, yes, the recording will definitely be available. We'll send it out, and it'll be available on our website, thinkcanna.com. Okay, first question then here from Leo. Thanks first for the kind words, Leo. That's very nice of you. Secondly, his question is here: should applicants scout for potential lounge style locations, or is it not worth the extra money / trouble since people can smoke outside or elsewhere? Anyone here want to field that one?
You're on mute, Ariel.
Yeah, sorry about that. I think obviously, yes, this is a business question. And I think that even though I think there is a benefit to the lounge, to the lounge setup, I think that, yes, you could smoke anywhere. There are people that just as you could drink anywhere, but there are people that prefer the lounge setting. I know marijuana is a little different than alcohol, but there are still people that prefer the lounge setting and the social ramifications. Does that mean that's necessarily a great investment? That will really depend on more, I think, on how well it's done and how well it's carried out than the actual model itself. But yes, there should be room for lounge style locations, in the fact that there is a I know because of COVID, that people are questioning how much social interaction we need, but yes, just as bars, the bar setting works for alcohol, even though you can drink anywhere, the lounge setting should work for cannabis, even though you could smoke theoretically anywhere.
Great, thanks for that, Ariel. Our next question, I think this one's probably directed towards Matt here. A little crystal ball telling. How long do you foresee 280E being applicable? Is it expected that this will be overturned in the next 2 to 5 years?
Yeah, again, it's just a matter of Schedule 1. It's a matter of reclassifying it off Schedule 1. At that point, 280 Cap E no longer applies. Summer, can I take a couple minutes just to touch on the tax aspects of the MRTA?
Sure.
And I'll for about 120 seconds, I'll run it down. So New York, to my knowledge, Summer and Greg can probably verify this. New York, to my knowledge, is the only state that's going to put a tax on distributors. It's kind of like a value-added tax based on potency. I don't know of any other state that will tax based on potency, but the way it's going to go with distributors is cannabis flowers are 0.5 cents per milligram of THC. Concentrated cannabis will go 0.8 cents per milligram, and edibles will go at 3 cents a milligram. That's on distributors. On the retailers, you got a 7% excise tax on medical. That's always been there. but there's a 9% retail sales tax that overrides regular sales tax in New York. You don't have to pay regular sales tax. You instead have to pay the special marijuana sales tax. 9% at the state level. Ariel was talking about what the localities are going to do. They can impose up to 4% at the local level. So you do have to be aware that there could be up to a 13% total retail sales tax on marijuana. And finally, the other thing you need to know is that all your other taxes that would normally apply at the state and local level, they're going to apply. The other than the sales tax I just talked about that gets overridden, everything else applies. So you're running a regular business, plus you got the sales tax stuff to deal with. So you should be aware of that.
Yeah, and in the context of the municipal opt-out, one thing I've heard the different municipalities are talking about is, well, there's really 4% tax, 1% is going to the county, there's 3% left, and that's going to be split between, you know, town, city, village, and a lot of these local, like, you know, Westchester, there can be, and Long Island, there's like a city, and then there's a village within that, so there's basically a local village deciding, well, do I want a headache for like 1.5% tax? And a lot of them are saying, even if, you know, we think it makes sense, it's not worth the, so that's where I think a lot of the context of municipal opt-outs coming in and out. I just wanted to mention that because I've seen that in the commentary and people, the politicians talking about that.
Great. All right. And Matt, I think this next question is probably also for you, but, and maybe you could address this afterwards if it needs to Ari here. If cannabis is no longer a Schedule 1 or 2 item, would the prior expenses be deductible? If not, are there any additional strategies available to capitalize as many costs as possible?
So if they reclassify off Schedule 1, I don't believe it would be retroactive. It would only apply prospectively to all present and future tax years during the year of moving the schedule. So if they decide to declassify off Schedule 1 in 2022, it's the tax year 2022 and forward. It is they're not going to let you do it for prior years. As far as capitalization, I mean, look, you know, I'm not an expert on the UNICAP rules, which determine if you capitalize or deduct something, but you can dive into those rules. You can try your best. You see how much you can stuff into capitalization, but expect some pushback from the government if you try and get too cute.
Yeah, exactly. That's what you have to weigh, right? How much are you saving versus what's the likelihood of being audited, and how long do you want the IRS on your back, right?
Yeah, not only that, but just to clarify, at the state level, the Department of Taxation and Finance is still going to handle all tax matters related to marijuana businesses, including the marijuana retail sales tax. So you're dealing with, and the DTF, they know the state badly needs money, and they're taking hard lines in a lot of these audits. So you don't want to attract any extra special attention from them either. You know, as far as the service is just brand new ball game. It's really going to depend on the exact issues and how they deal with it. But I like dealing with the service. Service is more technically inclined, and they're more practical when striking a deal. The Department of Taxation and Finance, they strike a very hard bargain. So you end up on their radar. It tends to be more difficult. Well,
that's good to know. Definitely some inside knowledge there. I forgot we had a couple questions submitted before the webinar, so I do want to get those. Paskey here has priority. So first was, how long does the licensing process take? Greg, do you want to take that one?
Sure. So Georgia showed us the shortest ever. 2 days before Thanksgiving, they announced that it would be open December 1st to December 31st. Actually, it wasn't quite the 31st, a couple days before that. So that was a very tight window. Other states are much nicer and give us a better heads up about it. But you can expect something like getting notice 60 to 90 days generally before the deadline. And then it's off to the races. So you can see the importance of some of those stuff we talked about earlier of trying to get it lined up now, because there's finite resources and other folks are doing it. And also because there's so many hours in those 90 days to get it all done.
Thanks, Greg.
And then, yeah, after the application period, it's somewhere between 3 months and multiple years if you're in Illinois, until they actually award those licenses. Then there's a period of litigation. Normally, businesses are able to be setting up who were awarded while that litigation is going on. So we have seen some states freeze that.
Great. Paskey, we'll get back to you with your first question on Canna Advisors, working with Canna Advisors. Certainly we'll reach out to you for that. Next question was, can you place another business under the same EIN or does every business have to have their own EIN number?
So I would say if you're planning this the way that gets you the best position to argue that the other business is going to be outside of 280 Cap E, you're going to have two EINs. There's an exception to that if both of them are treated as sole proprietorships. But even then, right? I don't know if it matters. So you have a single member LLC. Number one's cannabis. Number two is non-cannabis. The IRS actually says that unless you have payroll in both businesses, which you probably will, if you have payroll, you need two EINs and two LLCs. So most of the time, if not all the time, you will have two EINs. But it's not going to make that big of a difference if you have two single member LLCs, both of which don't have any payroll, and you use your social security number for both of them. Fine. But most of the time, because your entities are going to have payroll, two businesses, two EINs. That's the way it's going to work.
Great, thanks. Yeah, I think that's pretty clear there. Let's see, a question from Brian Betrowny here. Any insight on the GMP requirements for manufacturing infused products? Will this require GMP 111 or 117? I can go ahead and take that one if no one else does. I don't think we know yet if New York's going to require GMP. We don't see, not many states are explicitly requiring it in their regulations or in their statutes. Definitely a good practice. You know, as far as GMP goes, unclear, right, which way we're going to be going with cannabis, if it gets rescheduled, if it gets taken off the schedule altogether, to see where it's going to fall, whether it's going to be considered a supplement or under the pharmaceutical drugs for GMP. So hard to say there, but definitely great to be thinking about that now and planning ahead for GMP, you know, at least getting the baseline set for either of those sections, right? Making sure that you have your processes dialed in, everything's repeatable, you know, you have cleanable surfaces and everything can be sanitary. So certainly thinking about GMP is good, but yeah, I'm not sure right now if we know what direction that's going to go or if it would be explicitly required.
Yeah, the MRTA just references them and said either or with further regulation to come. So that'll be something to watch out for.
We'll see then. All right. Thanks, Moish. All right.
Oh, I just want to add one last thing. Some of that we've seen in some states that sort of insinuation in statute and that they go with like we're not really going to check up on it stance at the regulatory level. It remains to be seen whether that gets repeated or ends with New York.
Right. All right, then. I think one last question here, a little bit over already, but from Sharif, I'm going to lease a location with an existing structure on it and plan to replace with a new building after I obtain my license. Would I be able to get the license with the approved building plans, or should I submit with the existing building?
So really, I think it's a question of timeline. I think that if this is going to be a drawn out process in terms of knocking down and building the new building, then it may make sense to go with the existing building only because one of the factors for awarding licenses is going to be the proximity and density of other locations. So if you want to get your location in there, and this is going to take a while in terms of constructing a new building, you may want to file right away with the existing plans just so you have that location, and then file an amendment once you have the new plans and are going to change the building and build a new building. That way your location is already there. If it's going to happen quickly, it's unclear how they'll react to having plans. They may be, you know, because there is a focus on the actual location and the entrances and the exits and how it's located on the street. I'm not sure how comfortable they'll be with basing it on the plans itself. So there is a risk there. It's unclear as of now. As I said, if this process is going to take a while, the safest thing is to get the license now based on what's there now, and then go for an amendment later. But again, that's basically the best option.
Yeah, from my experience during the licensing or the application process, they're going to want to at least see the floor plans. If they're asking for floor plans, they mean the floor plans of your future business, what you plan to put together for, for example, your dispensary. They want to see where your retail sales floor is in those sorts of things. So they wouldn't want to just see your existing building, right? So just to clarify there. It looks like we have a couple more questions over here. Okay, here was one about social equity. Let's see. In terms of social equity applicants, can you define distressed farmers? And can you highlight the advantages of social equity candidates? Actually, we can send you our link to the previous webinar we did. We talked in great detail about social equity and in particular about distressed farmers and about the advantages of being a social equity candidate there. So certainly there are, but I think maybe outside of the scope of what we're chatting about today, we can send you a direct answer to that after the chat, especially since we're 5 minutes over here and I want to be respectful of everybody's time. All right, with that, I think we should probably wrap it on up here. Thank you all so much for joining. It's been an absolute pleasure. Thanks to everyone at Falcon Rappaport and Berkman for being here, joining us at Canna Advisors, and all of our participants here and your thoughtful questions. Looks like even more questions are rolling in, so we'll send out answers to those afterwards. Thank you all.
Thank you so much, Summer and Greg and Lisa and everyone else in your team for having us.
Thank you.
Thanks, everybody.
For all the co-panelists and attendees. This was a blast. I hope everybody has a great rest of their Wednesday.